Hello and welcome everyone. We are live with another episode of Level Up Law, where every Tuesday at noon here at South Carolina Legal Services, we are leveling up your legal knowledge about an area of law that we practice in. I'm attorney Susan Ingalls here with our producer Kenneth Elliott, and you are viewing our excellent staff attorney Charlotte Osmer in our Greenville, South Carolina office. And Charlotte is going to be talking today about name and gender marker changes so we can learn how to update your name and your gender marker here in South Carolina. A really great topic, and we appreciate you being here, Charlotte. But before we get started, we do want you to know this is not legal advice. It's just general information for the public. But if you do need the help of a lawyer on something like this or any other matter that we handle here at Legal Services, we definitely encourage you to call our intake line or apply online. All of that information will be provided for you at the end of this presentation. Also, as a reminder, all of our episodes of Level Up Law are posted by our producer Kenneth Elliott to our YouTube channel on the Level Up Law playlist, and that's usually done within 24 hours. So you can look there if you missed it, or if you want to share the broadcast with someone you think it may be helpful to, or someone that just may be interested in the topic. Now, I do want to say that Charlotte can answer general questions about this topic for us today, so we'll pause a couple of times throughout the presentation. So be sure to post any questions that you have right there in the question box. And again, we will be posting this on our YouTube channel as well. So without further ado, I'm going to go ahead and turn it over to attorney Charlotte Osmer. Take it away, Charlotte.
Hey, thanks so much, Susie. I appreciate that introduction, and thanks to Susie and Kenneth for all the production they do behind the scenes for these presentations. So today we're going to be talking about name and gender marker changes and how to update those name and gender marker changes in South Carolina. So first, we're going to then talk about adult name changes, and then we're going to separately talk about adult gender marker changes, and then we are going to talk about minor name and gender marker changes. And after each one of those sections, I'm going to pause to see if you have any questions about that specific section. At the end, I'm going to go through some frequently asked questions that I get in these type of cases, and I think it'll help illustrate some of the issues that you may encounter. And then finally, again, at the end, I'm happy to answer any additional questions you may have. So first, we're going to talk about adult name changes. Adult name change is pretty straightforward in the sense that there is a statute in South Carolina. It's very specific as to what those requirements are. And so we're going to go through those requirements and the process to obtain an adult name change in South Carolina. So the first requirement is that you're going to need a fingerprint and criminal background check that's conducted by the South Carolina State Law Enforcement Division, or SLED. You're also going to need a screening statement from the Department of Social Services that indicates whether the person who's seeking that name change is listed on the Central Registry of Child Abuse and Neglect. You're also going to need an affidavit that indicates whether that person is under a court order to pay child support or alimony. And lastly, as part of the criminal background check, you also need a screening statement from SLED, whether that person is listed on the sex offender registry. So we're going to talk about each one of those requirements individually. So first, we're going to talk about that fingerprinting and SLED background check. So it's possible to go on the SLED website and just quickly do almost instantaneously a criminal background check, and that's just submitting the information that SLED requires. But for an adult name change, you actually need to do a fingerprint background check because that SLED screening statement that you can do on the website, that's just based on the information you're providing. You're kind of self-reporting that information. But to do a name change in South Carolina for an adult, you actually have to be fingerprinted. So this is the fingerprint card that you need to use. You can go, if you're in Greenville County, you can go to the Greenville County Law Enforcement over there on McGee Street and get fingerprinted. Anywhere else, if you're across in any other county or across the state, you can go to any law enforcement center to have that done. In Greenville County, that's $10. Other law enforcement might not charge or charge something comparable. In addition to that fingerprint card, you need to do this record check for a name change. That includes the information. So when you submit that fingerprint card and this document to SLED, this is the actual document you're going to get back from SLED. If you do not, and that's what you need to attach to your petition, if you do not have a criminal record, it'll say so on this document. If you do have a criminal record, it'll also, you'll get this document, it'll say you have a criminal record, and then it attaches a printout of your full SLED report or your rap sheet, your criminal record. This is also the document that contains that statement or that screening result of whether you're listed on the sex offender registry or not. So once you get that fingerprint card, you complete that document, you mail it to SLED in Columbia. You also need to include a self-addressed stamped envelope so that they can mail back those results to you, and it's going to be a $25 fee. Second, you got to do that DSS screening statement, and this document is available on the DSS website. It's pretty straightforward as far as how to complete it and what information you need to provide. The only thing is that that document needs to be witnessed or notarized, and then you mail that to DSS in Columbia, and it's only an $8 fee for name changes. Then you also have to do that affidavit of no support. This is one that I use in my cases. So it's just that the person who's seeking that name change does an affidavit, a sworn statement to the court. They state their name and they state whether or not they're obligated for any outstanding child support or alimony payments ordered through the court in the name of. And I have clients who might have used multiple names throughout their lifetime. Maybe you have a maiden name and then you married and now you have a married name. I have a client who at a young age, the mother remarried, and so the child started using the stepfather's name. So it doesn't matter. You just list all the names that you have used and whether you have been obligated by court order to pay child support or alimony. So once you get the screening results back from DSS, you get the criminal record document back from SLED, and along with that affidavit, you attach that to your petition that's then filed with a family court. There is a $150 filing fee associated with that, and you got to make sure you've got the required documentation that the court requires for you to initiate a petition with a court. After you've started that, filed that petition, you need to request a hearing. Most cases you will need to attend a hearing, but there are some situations where that hearing can be waived. And so then a final order has to be submitted to the judge for the judge's review and signature. If the judge does sign that final order, then you need to get certified copies of that final order from the clerk's office. At this stage, then, the court has now ordered, if they've granted it, your name has been legally changed in the sense that the court has issued it. But if you want your birth certificate amended to reflect that court order, then you actually need to take an additional step and ask DHEC, the South Carolina Department of Health and Environmental Control, to actually amend your birth certificate to reflect that name change. So this is why it's important to get a certified copy of that final order, because that's what they require. If you just send a regular copy, they're going to send it back to you and they won't do the actual change on your birth certificate. You also have to do the vital records birth application. You need to include a copy of your state issued ID, and it's $27 to have your birth certificate amended to reflect that name change. This is what that vital records birth application looks like. It's available on the DHEC website. It's pretty self-explanatory on how to complete it. In that situation, you have the choice either to mail it in to DHEC in Columbia. It used to take about 4 to 6 weeks to get that amended birth certificate back due to shortages. I'm sure it's just taking longer now. So it could take up to 8, 10, 12 weeks sometimes. The other option, if you're really in a hurry, you can go to the actual DHEC Vital Records office in Columbia, located on Bull Street. And as long as you've got everything that you need to get that birth certificate amended, they will process it and give you and issue you your new amended birth certificate on the, on the spot. That takes, there's some delays and you got to wait a little bit to get that done. But if you need it, they will process it same day. If you go in person, it can only be done at the Columbia office of DHEC. You can't go to any other satellite office for DHEC across the state. So Susie, at this point, I'm going to see if anybody has any questions for me on adult name changes before I head into adult gender marker changes.
Well, Charlotte, I don't see any questions, which always suggests to me an excellent presentation that was so well done that there's no questions. You went over that really nicely, and so thank you. And I would just say continue on with the next section.
Absolutely. And like I said, at the end, I'm happy to answer any questions that anybody may have. So now we're going to move on to adult gender marker changes. So like I said, for when we do adult name changes in South Carolina, it's very specific and what's listed in the statute as to what your requirements are to pursue that. However, for adult gender marker changes in South Carolina, there is no statute or case law addressing gender marker changes in South Carolina. So what do we do? What do we use? There is one law that gives the family court exclusive jurisdiction to correct a birth record. So at least we know that we can pursue that in a family court because they do have the jurisdiction to correct birth records. There's another law that says the South Carolina Department of Health and Environmental Control has the authority to correct mistakes on a birth record. So as we just saw with that adult name change, the court can issue the order, and then this says that the health department would then have the authority to correct any issues on that birth record pursuant to that court order. So there is, like I said, it's clear what court we need to be in and which court has the authority to do it. But like I said, there's no other case law or statute that governs adult gender marker changes. So in 2018, the South Carolina Department of Health and Environmental Control issued a guidance letter for this very reason on this issue. And so they were very specific as to if the court and the medical professional are satisfied about the gender marker change, then as long as these 4 steps were followed, they would accept a court order and amend that birth certificate to reflect a gender marker change. So the first requirement is that there has to be a medical certification of a physical change related to the person's sex, that a licensed physician and the court are both satisfied their medical treatment has been completed, with the result being that they are now a different sex from their biological sex at birth and is not merely in the process of transitioning, that the change is permanent in nature, and lastly, that the change in sex is made with the intent to change permanently and for all purposes. So this is the only guidance that we received from the health department, but as far as that I've interpreted it, is that you're not required to have surgery in order to be able to change your gender marker on your birth certificate. And so as long as you have a licensed physician and the court are both satisfied that that medical treatment has been completed, it's permanent, it's irreversible, and so now that your doctor is saying that now biological sex has to be is different, as long as they're at medical certification and the court's satisfied, DHEC will accept that court order and change your gender marker on your birth certificate. So far, it seems has been pretty straightforward. Of course, what you're going to need though is that medical certification from your doctor. So what counts as a medical certification? One of 2 things. For the most part, we get started with a very detailed affidavit from the licensed physician treating the petitioner in support of that correction of birth record. And so, like I said, it's usually several pages long. It is very detailed on who they are, what their medical education has been, how long they've been treating the petitioner, how long, what type of treatment they've received, and then they make a declaratory statement that says this person is now a different gender that was assigned at birth. In certain cases, it may be necessary for that licensed physician to come to court, and their testimony may be required, but it just depends on a case-by-case basis. In addition, the petitioner's testimony is also going to be very important. And so in preparation for these cases, I'm very help my clients prepare a very specific type of testimony that also outlines those requirements that DHEC has set. And so it's just to make sure that both the doctor and the petitioner have been very careful in following those requirements and to make sure that it's very clear that those requirements have been met. So I go ahead and prepare my client with explaining their whole background, when they were diagnosed with gender dysphoria, what sort of treatment they received, what sort of permanent biological changes they have experienced, and that this is ongoing. So like I said, surgery has not been required, and it's okay that if you have you're undergoing hormone replacement therapy, it's understandable that that therapy is going to be ongoing. So just because it's ongoing doesn't mean that you're not going to be eligible to do it, as long as your doctor said that we've reached a point where now this is permanent and irreversible and we need to change the gender marker on the birth certificate. So Susie, any questions so far on this subject, on adult gender marker changes?
Actually, one question here, which is you said that it depends on the case as to whether or not the doctor has to actually come and testify about it. And how is that determination made?
Well, that's like, it's going to be it's kind of case by case. I've had a situation where the judge required it. So like I said, we just get started with that affidavit, and then it's just going to be up to the court on what they're going to need to see and if they're going to require any further evidence. So I've had a judge in the past require then medical expert testimony.
Okay, that's it for now.
Okay. Sounds good. So now we're going to move on to minor name changes. And so there's quite a few differences to adult name changes. First, obviously, the child does not have to do a criminal or DSS background check. Obviously, they don't have to do an affidavit stating that they're obligated to pay child support or alimony. However, both parents need to be named as parties in this action when it's involving a minor child. So there is an exception in certain cases where you'd have to petition the court to waive having to name both parents, but that would be, discussed separately. And the really big difference is going to be that a guardian ad litem is going to have to be appointed for that child. And so a guardian ad litem in South Carolina is an individual who can be an attorney, doesn't necessarily have to be an attorney, who is assigned in family court cases involving minor children to represent that minor child. So in most court cases, you have the attorneys who are going to be representing the parents, but not the child. And so this guardian ad litem is appointed to represent that minor child. That guardian ad litem then conducts an investigation and makes a report to the court as to what's going to be in the best interest of the child. And that's going to be ultimately the standard in family court for anything involving a minor child, is going to be what's in the best interest of that child. So you may be legally, you might meet the legal requirements of pursuing a name change for a minor child, but that's just one step. It's going to be like, okay, well then sure, you have the legal authority to request it, but ultimately what's going to be in the best interest of the child. So there is also a case on the subject. There's about 9 factors that are evaluated when determining what's in the best interest of the child, as well when doing a name change. So that's why there's going to be a little bit of a difference, is that they don't have to do some of those initial background checks and so forth, but they are going to need a guardian ad litem appointed to represent that minor child's best interest in court. It cannot be a parent. It has to be a totally separate independent person who's been trained as a guardian ad litem. So going forward then to what about minor gender marker changes? So perhaps that's possible. I just have never done one personally. I've done minor name changes for a transgender minor child, but I've never done a gender marker change. However, I would think that if that minor child has undergone the same treatment and a doctor is able to make a medical certification that their gender needs to be changed on their birth certificate, I would think it's possible. That guidance letter from the health department does not state that it's just applicable to adults or just minors, or it excludes minors. So I would think it's possible, but again, in this sort of situation, you would also need a guardian ad litem who's going to then represent the best interests of the child in the court action and going to have to make a report to a judge on that. So like I said, it's my understanding that some doctors are working with minor children to start hormone replacement therapy at a younger age, perhaps even before puberty. But that is just something that is going to have to, like I said, be assessed on a case-by-case basis, and if that doctor is willing to write that medical certification on behalf of that child and the family. Susie, any questions about minor name or gender marker changes?
Yeah, one question on the minor gender marker changes. says, would the parents both have to agree in that situation, or can it be done if one of them does not want it done?
So that's a great question, and that's what makes things very difficult when you're having a minor child, is that, like I said, both parents have to be named. So if one parent doesn't agree and the other one does, the one parent has to then initiate the court action, but has to name the other parent. The other parent then has to be served. The other parent has the right to have an answer. So it'd be like any other action, like a custody case or anything like that, where there's a disagreement as to what's in the best interest of the child. And so, like I said, that would ultimately, the guardian ad litem would have to be involved to investigate and make their own recommendation. The judge is not required to accept what the guardian ad litem says, but they certainly take it into consideration. And that would be ultimately up to the judge to determine what's in that child's best interest. But both parents would have to be named in any action involving their minor child.
Yeah, that's interesting. I guess the guardian ad litem has an important role in that situation. It would be interesting to see. I would think this is not, I guess my own question is, would that ever be possible? But I guess with a guardian ad litem, that was on the side of actually granting the marker change, and maybe if one of the parents didn't, I guess, put up enough of a fight over it, even though maybe they didn't agree, I guess it could be possible. But I wonder how a court would view that.
Exactly. I think this is kind of a novel area, and so, but it's up to, ultimately, one parent can pursue it if they're in favor. The other parent can be opposed to it. The guardian ad litem can investigate, make their own report, but it's ultimately going to be up to the judge in that case to make that determination. So I think that's kind of difficult if that child has already undergone that hormone replacement therapy. I think that would be a difficult case to oppose if already you have that medical certification that their gender is now different from the one assigned at birth. But like I said, this is never done one, and so it would be certainly interesting and certainly novel for most courts and judges.
Yeah, for sure. Interesting.
So I'm going to move on to some frequently asked questions. And so I've got 2 slides on some frequently asked questions. And after I'm done with these, I'll open it up to any other questions people may have. So one of the first questions I usually get is, do I need an attorney to do this, to do a name or gender marker change? And I would say probably. If you're just doing the name change, like I said, the statutory requirements are pretty explicit in what you need to do. And so, but if you're doing the name and gender marker change, I would recommend getting an attorney, because there is no statute or case law addressing that gender marker change. So it's probably best to have an attorney to make sure that, the requirements that have been outlined for gender marker changes, have been met, and make sure that you have the strongest case possible, and to avoid any delays. If you decide to do it on your own, it's certainly possible, but just like to remind people that if you go to the clerk's office at the family court, they are prohibited from giving you any legal advice. So you're kind of on your own trying to figure it out, and that gets frustrating for people sometimes. Another question related to this that I get is, should I do them at the same time? And if you can, and if you meet the gender marker requirements set forth by the health department, certainly do so, just so you don't have to initiate 2 separate court cases, go through court, have a hearing twice, and then have your birth certificate amended twice. Because every time your birth certificate is amended by court order, it's listed at the bottom and what the reason was and so forth. And so it's just probably easier and more efficient, if possible, to do them both at the same time. Another question I get a lot is, I live in South Carolina, but I was born in another state. Can I do a name or gender marker change in South Carolina? Yes, you are a resident of the state, and therefore you're subject to this court's jurisdiction. So the only thing that's just different is that, every other state is required to accept a court order from South Carolina, just as South Carolina is required to accept court order from other states. The only thing I just always double check with other states and their vital records department is to make sure that there's nothing different that they might require, make sure that everything they require, is contained in the court order. If I need to have anything special in there, but for the most part, I've probably done name changes for clients in about maybe 20 other states. I've never had any issues, and so far, like I said, they're pretty much standard requirements. Once you get that court-ordered name change, what you need to do to submit it and actually get that birth certificate amended. The only thing that's new that's kind of developing now is gender marker changes, and so each state, some states might have, specific laws addressing it. Like I said, South Carolina doesn't. And so one issue that I'm starting to see now with newer cases is that, just want to make sure, some states are requiring gender reassignment surgery for you to qualify. So then it's just making sure you reach out to that vital records department and make sure that if if a judge orders that name and gender marker change in South Carolina, is that state's vital record department going to accept it, or there's going to be any issues? And so it's just to make sure that even before you get the case started, so you don't have any delays in doing so. So on the flip side is I was born in South Carolina but live in another state. I was told I had to pursue the name change in South Carolina. Is this true? No. And so, but I do seem to get this a lot from other organizations who seem to think that this is a case and tell clients accordingly. So I've had people living in Minnesota, Oregon, New York, and they've been told that they've been living there for 20, 30 years, but then they have to return to South Carolina in order to get a name change. So I just always explain that that's just not necessary. South Carolina and the health department here will accept a court order from any other state. Like I said, it just has to be compliant with any, make sure you have that $27 and you have your state ID and you have a certified copy. So just those requirements have to be complied with, but South Carolina will accept a court order from another state if a name change has been ordered. I would think regarding a gender marker change, that what I've noticed here in South Carolina is that even though I've got the medical certification and I've got the court order granting the gender marker change, DHEC is still asking me to supply. They just want to see a copy of that medical certification, and that's the affidavit, the sworn statement from the licensed physician who's treating my client. So those are just things, if you're out of state but we're born in South Carolina, just make sure, reach out to the health department and see exactly what they need in order to make any changes to your birth certificate if you're born in South Carolina but live in another state. So I have a criminal record. Will I be able to pursue a name or gender marker change? For the most part, you should be. So the statute does contemplate this very issue. And so the statute does say that if you do have a criminal record and the name change has been granted, that the clerk of court, once the case is closed, has to send notification to the South Carolina Law Enforcement Division of this name and gender marker change. However, ultimately, whether that name or gender marker is changed is up to the judge. And so, like I said, if the judge grants it, then simply, even if you have a criminal record, then simply that just needs to be reported to the South Carolina Law Enforcement Division. And similarly, I am listed on the DSS, the Department of Social Services Central Registry for Child Abuse and Neglect. Will I be able to pursue a name or gender marker change? Similar answer. The statute also contemplates this, that if there is somebody who's listed on that registry for child abuse and neglect, and the judge does grant that name or gender marker change, simply the clerk of courts sends a copy of that order to DSS to update the central registry. So like I said, but ultimately that decision of whether or not to grant that name change or gender marker change will be up to that judge assigned to your case. And lastly, if I file a case with a court to change my name and gender marker, will it be open to the public? And so a lot of my clients have asked me this because they want to be discreet in pursuing their name and gender marker. But South Carolina feels very strongly about having access to the public for, open access by the public to official and court records. And so for the most part, everything is available for the public to view. However, there are circumstances where a court record can be sealed. It's not common, and there are quite a few factors that the court has to look at in order to be able to make that decision. But I just want to state that there is a difference in family court cases versus criminal and civil cases. And so family court has its own court and system, whereas the criminal and civil, they are available on the public index. So if you go on the public index and you look up a a civil case where you were able, for the most part, to able to view all those documents online with no charge. You're able to view them. You do not have to go to the courthouse to view those. In family court, there's a way to see if somebody has filed or has a case pending or has ever had a case with family court, but those documents are not available to view online. You actually have to go physically to the courthouse, to the family courthouse, to look at that file in person. And any information related to that individual that is considered confidential, such as your social security number and dates of birth, those are going to be redacted anyways. So somebody couldn't see that information, let's say, or steal your identity. So like I said, it might be possible, but very rare for a court record to be sealed. But for the most part, somebody would, in family court, would have to go physically to the courthouse and view that record in person to be able to see anything about that case. Different than it would be in common pleas and civil court, where that information is usually available to view those documents online. And what about for a minor child? So that's going to be a little bit different because in any action in family court involving a minor child, you're not supposed to identify them anyways. And so as we talked about in a minor or gender marker change for a minor child, it's the parents who bring the action. And so any mention of the child in any court pleadings are actually going to identify that child only by their initials. Also, their date of birth is not listed on those documents. That's going to be on a separate document that's confidential and it's not going to be open to the public. And so for that minor child, it's going to be probably unnecessary to seal a record, although it might be possible, because like I said, the only parties and only names that would be listed on any of those court documents would be just the parents, and that minor child would only be identified by their initials. So that's kind of it. Susie, has any other questions come up in the meantime?
No other questions that I see, Charlotte. Very thorough presentation about a really interesting subject, and I thank you so much for really an excellent presentation. And I do want to thank our audience for being here, whether they are the audience on the live show or later on YouTube watching this. And I do want to say to our audience that if you found this helpful, again, and if you know it might be helpful to others or would just be interesting to share, please do go to our YouTube channel tomorrow at South Carolina Legal Services and on the playlist Level Up Law on that channel, and share the broadcast out. And while you're there, if you have not subscribed to our channel, definitely do that while you're there and sign up for those notifications. And that way, even if you miss the live, the registration for the live events, you'll always be notified when we post a recording, such as the one that we'll post of Charlotte's presentation today. So definitely do that. We want as many people as possible to get this important information so that they know that this can be done and how it can be done and how South Carolina Legal Services can help you do it. Now, you can see here on your screen all of the information about how to get in touch with us, how to apply for our services for this or any other legal issue, and also all of our social media where we post regularly great information and links for you, as well as resources and materials about all the different subjects and matters that we handle, whether it be on our main website, sclegal.org, or on our resources page of lawhelp.org/SC. So definitely go and check that out. And be sure to tune in next week when we will be having as our guest, and I would point out that it will be National Consumer Protection Week, which is near and dear to my heart as Consumer Law Unit Head here at South Carolina Legal Services. We'll have a wonderful lady, Rhonda Perkins, who is the Chief of Staff of the Division of Marketing Practices in the Bureau of Consumer Protection at the FTC. That's the Federal Trade Commission. And you might remember, if you're a regular here on Level Up Law, that we have already done a short episode just summarizing the report that the FTC did on how they are serving communities of color. And Ms. Perkins, who is actually formerly a legal aid attorney, so that certainly is good credentials, and she's been there litigating cases at the FTC for I think over 10 years. But she'll be helping us with a deeper dive into the FTC report. It summarizes, the last 5 years of the FTC's efforts to address, understand, and educate people about consumer issues that have a disproportionately negative impact on communities of color. And the FTC has been doing a lot of work in that area. So Ms. Perkins will be discussing an analysis, basically, of the consumer reports that come from the Consumer Sentinel Network. And that shows disparities in the reporting rates from Black, Latino, and white communities. We'll get some details about the types of fraud and schemes that have targeted or affected communities of color, and also all the free FTC resources that help consumers avoid scams and other consumer issues. So definitely that would be a great one to tune in for, so we invite you to do that. But again, before we go, I just want to thank Charlotte Osmer for such a great presentation. We really appreciate you taking the time to bring this important information to us on a really very new subject, but you've had some experience in handling these cases, and that's always really helpful in presentations like this to kind of have that experience and background. So you are talking about something that you really do know about. So thank you so much, Charlotte.
Thanks, Susie, for putting it together.
You bet. And again, thanks to our audience, thanks to our producer, Kenneth Elliott. And that will conclude our webinar for today. We'll see you next week on Tuesday at noon. Thanks, everybody.
Thanks.